Business and company names are not trademarks. This is one of the biggest misconceptions within the business community, but business and company names do not provide a right to use the name in trade. That's the role of a registered trademark, as you can see from abr.gov.au. Business names relate to state-based laws pertaining to operating a business, and company names relate to the Corporations Act 2001, which is federal legislation. Trademarks are governed by the Australian Trademarks Act 1995. So, what is a trademark? This definition comes from ipaustralia.gov.au, the government agency that is responsible for the Trademarks Office. And here's the definition from the Trademarks Act 1995. As you can see, the emphasis is on distinguishing the goods or services from one trader from another. And you can search the official Trademarks Register by accessing the Australian Trademarks Search website. Registered and pending trademark applications, as well as other information, can be found there. What about unregistered trademarks? Registered trademarks give their owner nationwide protection. That means once you have a registered trademark, you can use it for your goods and services across Australia and stop others from using it. Because it's essentially property, you can license it, transfer it, and so on. Trademarks can be protected across 34 goods and 11 service categories, also known as classes, as you can see here, which is taken from IP Australia's website. For instance, apps and software are in Class 9, and pencils, paper, and pens are in Class 16. There are 11 service classes, and for instance, all manner of design activity is in Class 42. Trademarks must distinguish the goods and/or services of one trader from that of another, as shown here again in Section 17 of the Trademarks Act 1995. There are 1,000 cafes in any one city, but we need to be able to distinguish one from the other. That's where good branding comes in, and a trademark is legal protection for a brand. So what makes for a registrable trademark? Well, here are some tips. To be registrable, trademarks cannot be descriptive of the goods and/or services they represent. For instance, Apple does not sell apples. So, an eyewear company called Just Spectacles or Just Glasses or Just Eyewear would not be protectable. Trademarks cannot deceive or confuse the public. For instance, you cannot use a famous person's name as a brand to represent a product or a service without their permission. A trademark cannot indicate that goods are from a certain geographical location when they are not. Trademarks for the same or similar goods or services cannot be likely to deceive or cause confusion amongst the public. Before handing over a new trademark, conduct a search of the Trademarks Register. You might want to work with a trademark professional to add this service. They will conduct a professional search of the Trademarks Register to see whether or not the new logo you have created, or the phrase, or icon, whatever it is that you have designed is actually not already a registered trademark. in which case handing it over to your client would be disastrous because they would not actually be able to use it. In fact, using it could mean that they could have legal issues from day one, and that's not what you want for them. Only registered trademarks can carry the registered trademark symbol. Here is the famous Radio City Music Hall in New York City. It's also an Australian registered trademark, and so is the word Rockettes, and that means that its owner has the right to use the registered trademark symbol whenever it promotes it on its website, in this Google ad for instance, at any time. Facebook is also protected in this country, as you can see from this search, which shows that the owner, Facebook, has 50 trademarks, all the way from its earliest trademark, which was Face in 2005, through to its most recent trademark, which is very interesting because we haven't actually seen it in the marketplace yet, but you'll see it shortly, and it's Bonfire. Registered trademarks make businesses more valuable. Registered trademarks provide nationwide protection, can be renewed every 10 years indefinitely, can be sold and licensed. Business and company names and brands have none of those attributes. You might still legally own the trademarks that you have created. The reason why this is because intellectual property is generally owned by the creator or author unless it is legally assigned to another party. And generally, simply paying for it does not mean that the trademark has been legally assigned to the client. It's good practice to have a handover procedure that includes the legal assignment of the trademark or trademarks that you have created from your design studio to your client. That can be easily done in most cases with a deed of assignment, for instance. We can help you in many ways. Just go to comoip.com/contact and be in touch. We can search and protect your design studio's name so that you have a registered trademark, which will make your business more valuable and will mean you can stop others from using your name. Now stick around for the next minute to revise the 10 trademark secrets.